Good afternoon, everyone, and a very warm virtual welcome to the International Institute for Strategic Studies. My name's Eleanor Beevor, and I'm a research associate with the Conflict, Security and Development Programme. I can still see numbers building on screen, so we'll wait for another 1 minute or so before we begin. But in the meantime, I'm just going to run over a couple of housekeeping points. If you have questions, please submit them. You can submit questions at any time through the Q&A panel at the bottom, or you can also, and we will answer those after each of our panelists has had their turn to speak. And so please feel free to submit written questions at any time. And if you'd like to ask a question live in the question portion, please feel free to raise your blue hand as well. And we will do our best to get through to everyone's questions. Please note that this webinar is being recorded and will be posted on our website shortly after the event. Our panelists are each going to have their turn to speak. Cordula Droege, I'm sorry. So yes, first now a warm welcome to the first IISS climate briefing, a monthly series of events in which we'll examine different aspects of environmental security. We've got an extremely exciting topic and a fantastic panel to kick off the first one. Preserving our natural environment is critical for all of our survival. And yet in the face of armed conflict, there is a huge amount of uncertainty about whether it's given any legal protections in international law. But if we are to try to protect the environment in war, there are a lot of people who need to know the answer to this question, including militaries, non-state armed groups, environmentalists, and the international policy community. We are very lucky today that we have a panel who are exceptionally qualified to try and answer this big question. I am delighted to welcome Jonathan Sommer, the legal advisor for the Danish Red Cross, and Stavros Pantazopoulos, who is the legal and policy analyst for the Conflict and Environment Observatory. Dr. Cordula Droege, the Chief Legal Officer for the International Committee of the Red Cross, should be joining us very shortly. This might, yeah, here she is now. Please, a very warm welcome as well to Dr. Cordula Droege. Thank you all so much, and Cordula, apologies for the technical trouble you had. At the risk of slightly putting you on the spot, perhaps I could ask you to kick us off with your first presentation. Thank you very much.
Oh my goodness.
Sorry.
Thank you very much, Eleanor. It's nice to see you again like this virtually, and thank you also to IISS for inviting the ICRC to join the discussion. I'm really delighted to take part in the conversation. I'm still a bit nervous because I just spent the last 20 minutes trying to join, but I think it's all good now. So I will try to make a few remarks today about three things, three areas. The first is why we need action to protect the environment in conflict, perhaps now more than ever, and why it should be based on the framework of international law. Secondly, on how the applicable legal framework under international humanitarian law protects the natural environment in armed conflict. And you asked also specifically to talk about non-international armed conflicts, Eleanor. And thirdly, what can be done to strengthen the protection? As you remark in your event description, of course, there is a gap between what the law says and what the reality is, as so often in international humanitarian law. So we need to pay attention to what we can do practically to put the law to the service of the environment. So first, why international law must protect the environment? Of course, the environment suffers in armed conflict, and it suffers particularly in prolonged armed conflict, which are many of the conflicts today. And we've seen that throughout history, you know, from Vietnam to Kuwait to Kosovo to the recent burning oil wells in Iraq, that the environment can really have lasting scars from wars. Why is that? Very often parts of the natural environment, such as large forests or fields, are directly attacked or incidentally damaged, just simply by war fighting. They are also impacted by damage caused to the built environment. For instance, when you have water, sanitation, or electricity services that are disrupted by hostilities, And similarly, fighting can lead to water and soil and land contamination, for instance, rendering drinking water and agricultural land more scarce for civilians who are already, and particularly, as I said, in prolonged conflict, in desperate need. You also have the problem of explosive remnants of war, which we see a lot in armed conflict and after armed conflict, and they remain etched into the landscape. They cause contamination, and at times, of course, for decades. You also have the issue that biodiversity can be irreparably damaged because war is waged in hotspots. And I think many of you know these examples, for instance, about the DRC, but you have many fragile environments, of course, in the places where armed conflicts are fought today. And I'll say something about this in a minute as well. Also, why does it matter? Of course, you can say it matters intrinsically because the environment in itself has value and shouldn't be damaged, but also because the consequences of the environmental damage for the civilian populations are really severe and complex. Why? Because they, of course, civilians depend on the environment for food and water. Farmers, herders, fishing community depend on them for their livelihoods. And so when the environment is destroyed, food and economic insecurity intensifies, physical and mental health of conflict-affected populations deteriorate. Often, in order to cope, they have to diversify their livelihoods, which sometimes can have secondary effects on the environment. They have to move, which can lead to, so it leads to displacement and other areas which might be then affected, which might already be fragile or not have the capacity to really still have more people using the resources. And what we've observed at the ICRC is that this capacity to adapt, which civilian populations have in all armed conflict, constricts, of course, as the conflict and the environmental degradation continue and sort of reinforce the erosion of the resilience of civilian populations in such situations. And then perhaps a word about climate risks. We're talking here mainly about the environment or the natural environment, but of course this is against the backdrop of the severe risks for the climate that we see. And there's a combination here and a sort of a vicious circle between armed conflict environment, armed conflict, violence, environmental degradation, and this sort of makes matters worse and worse for civilians trying to survive in contemporary armed conflicts. And what we do know is that countries in situations of armed conflict are disproportionately impacted by climate variability and extremes. And this is partly because of their geography, but also because conflict and their consequences limit the adaptive capacity of people and systems and institutions. And so, for instance, according to OCHA, the world's 8 worst food crises are all linked both to conflict and to climate shocks. So when you have environmental degradation colliding with climate shocks, of course, then the food and economic security and health disparities are exacerbated, and civilian populations are weakened even more. Now to the rules of international humanitarian law, quickly, that protect the natural environment. You have sort of, broadly speaking, 3 types of international humanitarian law rules that protect the environment from war fighting. And these include also rules that apply in situations of non-international armed conflict. So the first type is the rules that are specifically meant to protect the natural environment. These date from the 1970s, so from the Additional Protocol of 77, and include the prohibition against the use of means and methods of warfare that are intended or maybe expected to cause what is called long-term, widespread and severe damage to the natural environment. The environment is also explicitly protected against reprisals. Now, in the 70s and in the first additional protocols, these rules apply to international armed conflict. But what we see today, of course, is that in many legislations or military manuals, these rules are also incorporated into national law without making difference between international armed conflicts and non-international armed conflicts. So we can arguably say that they start applying also in non-international armed conflicts. Now, the second type, and this is perhaps these are perhaps the rules that are often overlooked, but in fact are perhaps almost more important to protect the natural environment. And these are just the basic rules on the conduct of hostilities. And that is because, and these are rules that protect civilians and civilian objects from the effects of warfare. So the principle of distinction, the principle of proportionality, the principle of precaution. And the natural environment is considered, either in its entirety or parts thereof, which is a bit of an academic debate, to be civilian in character. And so, for instance, the principle of distinction requires that attacks cannot be directed against parts of the natural environment unless it is directed against a specific part that has become a military objective. And thereby, of course, the natural environment is protected. And the principle of proportionality, I think, also plays an important role in protecting the natural environment as a civilian object, because it is thereby protected against incidental damage. And so those who are launching attacks have to take into account the expected damage that could be caused to the natural environment. And the principle of proportionality also requires us to keep in mind the foreseeable indirect, third and second tier effects. And that's important for the natural environment because that is often affected indirectly rather than directly by hostilities. And I would argue that whether an effect is reasonably foreseeable depends on the facts of the case, but this assessment, of course, has to be informed by past practices and empirical data. And as data becomes more reliable, we have more predictability as well on how warfighting can affect the environment. And the last type of rules that protect the environment in international humanitarian law are, on the one hand, the rules that protect specific objects. So, for instance, there's a prohibition to destroy objects indispensable for the survival of the civilian population, such as, fields, crops, water installations, and so forth. And that's, of course, critical for the protection of the environment. Rules on the protection of enemy property, rules against pillage, and then all the rules on weapons that have a bearing on the environment. So, of course, incendiary weapons, rules on, limiting the use of landmines, the prohibitions of biological weapons and chemical weapons, and so forth. And I think, as I talked about the combined effect of climate impacts, environmental degradation, and violence in armed conflicts, I think it's important also to think about the way that IHL can also alleviate or sort of reduce the risks of these climate shocks that affect populations in armed conflicts, because by limiting environmental degradation, better respect for IHL rules can also reduce the additional harm and risks for civilians that exacerbate the harm resulting from climate change. So, for instance, climate change can drive water scarcity or reduce the availability of arable land. And by prohibiting attacks on objects indispensable to the survival of the civilian population, such as agricultural areas and drinking water, IHL protects these resources from additional conflict-related violence. Climate change can also accelerate biodiversity loss, and I think I'll talk about it in a minute, how IHL can perhaps also protect specific zones from warfighting. Which leads me to the last and third part about what can be done and how the protection can be improved in practice. Because it's, of course, not enough that IHL rules exist on paper, and they must be better disseminated and implemented. And just to say there that to step up our efforts at the ICRC to strengthen the implementation of these rules, in autumn this year, we will release guidelines for the protection of the natural environment in situations of armed conflict. We had already done this, so the ICRC had issued such guidelines for military manuals in 1994. So this was after the Gulf War of 1991, and they were at the time submitted to the United Nations, and there was a General Assembly resolution inviting all states to give due consideration to the possibility of incorporating the guidelines into their military manuals and instructions. Now, as I said, they date from '94, and of course, since then, the international framework has continued to develop. And at the same time, there is really a need to look at the protection of the environment again. And so we are updating them. And perhaps the sort of the messages or what we want to facilitate with them in terms of practical steps of what could be done to improve the protection of the environment in armed conflict would be perhaps I'll just say three things. So the first one is to really disseminate and integrate IHL rules into the armed forces doctrine, education, trainings, disciplinary and sanction systems. Because the environment really is a bit of a silent casualty of warfare, and what you see is that there is not so much awareness about the effects of the environment, and it's perhaps not something that is taken into account as much in armed forces as it could be. So I think there's really a need for awareness raising, but also training and incorporation into the doctrines of the armed forces. The second one is to adopt and implement measures to enhance the understanding of the natural environment prior to military operations and also during military operations. It's a bit, as I said before, you know, if you want to protect the natural environment against either direct or in particular against incidental effects, there would be a lot of value in mapping the environment before military operations and in sort of keeping constant track of an understanding on how the environment will be affected by war fighting. And a lot, I think, more can be done there with much more modern data, more knowledge about how the environment can be affected. And then thirdly, a very practical thing that could be done is also to identify and designate certain areas, particularly biodiversity hotspots, for instance, or areas of particular environmental fragility as demilitarized zones. So for instance, national parks or natural reserves or endangered species habitats. Demilitarized zones are something that is foreseen in international humanitarian law. To make it very, very simple, basically, ideally they are agreed upon by the warring parties, so that both agree that they will not be used. They can also be designated unilaterally ahead of the conflict, and I think that could be something, and we are discussing as well with a couple of organizations about perhaps exploring more the possibility of designating such specifically fragile environmental areas. So we also have recently at the International Conference of the Red Cross and Red Crescent, which happened last December, a system of pledges where states and national Red Cross and Red Crescent societies can pledge certain activities that they would like to do in order to implement IHL. And some states and national societies have made a number of pledges to improve the protection of the environment in armed conflicts. So that's also, I think, a very practical avenue to explore to better protect the environment. So I'll leave it at that, and thank you, and sorry again for the late arrival.
Thank you so much, Cordula. I'm sorry, I feel a bit guilty for having thrown you in the deep end the moment you arrived, but that said, you gave us a fantastic start, so I'm not feeling as bad as I was. Thank you so much. Next up, we're going to invite Jonathan Sommer, who is legal advisor to the Danish Red Cross. Please do keep your written questions coming through the question and answer field, and then we can begin those more promptly. But in the meantime, Jonathan, the floor is yours.
Hello, and thank you, Eleanor. Thank you, IISS. Nice to meet you, Stavros, and nice to see a familiar face in Cordula. I was thinking if I get nervous here, I should just imagine the audience in their underwear, and then I realized, well, in these COVID times, maybe the audience is in their underwear. So let's leave it at that. One thing I will say is, as Cordula alluded to, some have made pledges according to the International Conference, Danish Red Cross as being a Nordic national society, and all Nordic states have done so. So this engagement actually is part of the implementation of that pledge. Can international law protect the environment in armed conflict? So I suggest that the answer depends on three factors. First of all, who are the duty bearers? If the law does not address the relevant actors, it will not be effective. So my presentation is going to specifically zero in on non-state armed groups, and I might use the acronym NSAGs. Once I get going, I interchange these, and which, depending on who is labeling them, refers to rebel groups, liberation movements, terrorist organizations, and even de facto states. The defining element is that they're parties to conflict who do not have legal capacity to become party to international treaties such as the Geneva Conventions. The second factor is whether the norms are adequate. Cordula already started to introduce this, and for the most part, I'll leave it to Stavros and Cordula, although I will address how these norms relate to NSAGs. The third issue is, are the duty bearers, in this case, non-state armed groups, willing and able to comply with these norms? Now, when it comes to armed conflict, there are two types of duty bearers, at least according to IHL, and that's states and non-state armed groups. In today's conflict, by far the most prevalent type of actor, in sheer numbers, if not environmental impact, are NSAGs. And in fact, while we can generally put a number according to, depending on who you talk to, on the number of states at around 195, there are currently upwards of thousands of NSAG parties to conflicts, meaning therefore bound by IHL and the environmental protection laws that are included. But it's not quite that simple, because as Cordula also said, some of the rules of IHL only apply to international conflicts. That means conflicts between states. So some of the rules, such as using destruction of the environment as a weapon, may or may not bind states and NSAGs in conflicts between them, because it's still unclear the state of the law. Again, because these types of conflict are the vast majority, this may create a normative gap. Now, we can look at other areas of the law. When it comes to international human rights law, there's several, like the right to water, life, and health, that relate to environmental protection. While the traditional view is that international human rights law does not bind directly non-state armed groups, an emerging view is that it does, at least when it comes to respect for fundamental rights regarding non-state armed groups that control territory. That would leave open the question as to what human rights bind what type of non-state armed groups. Then when it comes to environmental law, there's been much less consideration of extending obligations towards NSAGs. However, some of the rules come in through the back door when they're integrated into the customary IHL. But as I said, these may not all be relevant to NSAGs. So if we pull back from the silos of international law and look a little bit more generally, which Stavros is going to do in a few minutes, on the 29 draft principles on protection of the environment related to armed conflict, most of the principles only address states or mimic IHL obligations. There is in fact one interesting principle, which is principle 8, which includes other relevant actors. Among those that should prevent and mitigate environmental degradation in areas where persons displaced by armed conflict are located. So one might think that those other relevant actors might in fact encompass non-state armed groups, but according to the statement of the chair of the drafting committee, only referred to NGOs and development agencies in commenting on that particular article. There's also principle 23, which does encourage parties to conflict to address the environment in peace processes, but post-conflict, we never know really what the state of an NSAG is going to be, whether it in fact exists, continues to exist. And while IHL lawyers such as myself generally like to stay out of discussions on international law regarding the use of force, the legality of use of force, for example, the right to self-defense under the UN Charter, I will just mention that international law does not regulate the use of force when it comes to internal violence, internal use of force. At the same time, many non-state armed groups have been motivated to take up arms in the first place due to a feeling that the state was threatening environmental security or environmental integrity. So to be clear, IHL does not permit the bending of its rules, no matter how just the cause. But in terms of addressing root causes, we can see that if other areas of international law are capable of protecting environmental interests of populations, then there may be fewer NSAGs and fewer conflicts. So now, having addressed the first two issues, we'll come to, and how they apply to non-state armed groups, we can turn to the third, which is are NSAGs willing and able? So when we talk about willing, we can look to their doctrine, like again, Cordula referred to the doctrine that either states or non-state armed groups will have about environmental standards. This could be expressed in their codes of conduct, their internal rules, or other areas. And now, just like with states, or even just like with you and me, we don't always do what we say we're going to do. So we need to keep that in mind. Some non-state armed groups will be very destructive towards the environment, whereas others will be allies when it comes to environmental protection. One thing that we do know is that, while NSAGs often express their doctrine on other areas of IHL, like protection of civilians, very few of them have articulated policies on environmental protection. But when they do, they often go beyond environmental, actually beyond the standards of IHL. And I'll just give a few examples here. So one NSAG has said in their doctrine, forests will not be burned or otherwise destroyed. So this is at least in line with IHL and may even go beyond. Another has said, we shall do everything to protect and develop our wildlife resources for us and for posterity. So this is interesting because not only does it go beyond IHL, but it also implies a positive obligation towards intergenerational equity, which is a concept which is more known from environmental law than it is from international humanitarian law. And now personally, when I've discussed environmental standards with representatives of NSAGs, they're surprised generally that IHL is not more protective of the environment, and they'd like to see more. I mean, in fact, many go so far as condoning acts that would be contrary to IHL in order to protect the environment. So they actually say, well, we'll protect the environment in ways that wouldn't be consistent with IHL. And I give you an example here. One says that environmentally destructive operations of big business and multinational corporations make them valid military targets. Now, such targets would generally not be considered military objectives under IHL, and therefore international law would prohibit such tactics of environmental protection. As I mentioned earlier, IHL does not permit the bending of its rules, no matter how just the cause may be. Moving to willingness. Now, in general, willingness will be related to the incentives that any party to conflict, including a non-state armed group, will have to comply with international law. And I won't go into them deeply now, but in the question period, if you'd like to go into the incentives a little bit more, please feel free to ask. But I will note that just simply by taking up arms, non-state armed groups will be acting contrary to domestic law. So then finally, on the issue of able, are they able? There's several factors which are going to impact their ability, and actually Cordula mentioned again some of them: knowledge of the law, training, technical capacity, command and control, and internal discipline. So now I'd like to move to what can we do? Well, in the first place, we can recognize that non-state armed groups are not just part of the problem, they're also part of the solution. This is a sensitive notion, particularly for many states who see non-state armed groups as an existential threat and their engagement as a threat to the foundations of state sovereignty. But whether we like it or not, non-state armed groups are stakeholders in environmental protection. So as stakeholders, we can sensitize them to international standards and help them to integrate these standards into their practice. We can do more to gather their perspectives. and to include these perspectives in thinking about the adequacy of the law. And we may even have something to learn from them. I'd also, without addressing the legitimacy, we can also involve non-state armed groups in normative discussions. My former organization, Geneva Call, gathers dozens of NSAGs for periodic meetings on humanitarian norms, together with NGO representatives, representatives of international organizations, and even some donor states. Another example, as Cordula mentioned, and as we have two representatives of the International Red Cross and Red Crescent movement, is the International Conference of the Movement, which also involves states. Now here, as neutral actors, the movement can be better at finding a balance and creative ways to bring non-state armed group perspectives into discussions and to resolutions of the conference, while still recognizing the concerns that some states have towards conferring political legitimacy upon non-state armed groups. So in conclusion, not only do we need adequate laws, but they need to be addressed to relevant parties who are willing and able to comply with them. We can do a better job of understanding the perspectives of non-state armed groups and engaging them as stakeholders in normative processes towards environmental protection and armed conflict. Thank you.
Thank you very much, Jonathan. I'm going to quickly turn over to Stavros now. Stavros Pantazopoulos, the floor is yours.
Thank you. Thank you very much, Eleanor. I would also like to thank the International Institute of Strategic Studies for this kind invitation. Moving on to the second slide, I will focus on what was mentioned before, the United Nations International Law Commission draft principles on the protection of the environment in relation to armed conflicts, PERAC, as I will call them in their abbreviated form. I will pick two specific examples from these 28 draft principles to showcase how environmental protection can be strengthened in armed conflict. Then I will delve into a specific case study which is still impending, the safer oil tanker off the coast of Yemen. It's still going on. And I will conclude with submitting certain recommendations and compiling my findings. So let's start now, moving on to the next slide with the United Nations International Law Commission. What is this body? Its composition, its mandate. So this is a body of experts, international law experts, 34 independent international law experts. They are chosen because of their expertise, not because of their nationality. And this body covers all regions and legal systems of the globe. It enjoys high authority among international law circles. And in many occasions, and its mandate is to codify and progressively develop international law. It has done so since its inception in the late 40s, and it has promulgated very influential international law documents. In 2013, the International Law Commission decided to include in its agenda our topic, the topic of PERAC, protection of the environment in relation to armed conflicts. And last year, summer 2019, it adopted on first reading 28 draft principles, which will more likely be finalized next summer. At least this was the plan pre-COVID in summer 2021, to adopt these draft principles on second reading and then pass them to states, the United Nations General Assembly, where states will decide their fate. What is special about these draft principles? Why should we focus more on those? First of all, it's a temporal approach. We heard from Cordula and Jonathan about the work of the ICRC or the obligations of non-state armed groups. But these norms, these rules are mostly focused on the during armed conflict phase. The ILC has adopted a broader perspective covering the whole cycle of conflict, pre-conflict, during conflict, post-conflict, and also in situations of occupation. This is the first document of its kind, covering all these phases by focusing on environmental protection. Of course, this raises the question, what is the legal nature of this document? Is it binding? Are states bound by these draft principles? This question is tied to the ILC's mandate. We can find the answer there. As I mentioned, the ILC is endowed with the competence to codify international law, which means it will reflect existing international law norms, but at the same time, it will also put forth recommendations progressively developing international law. So it is a mixture of these two elements. And what is even more important for our purposes when it comes to non-international armed conflict, and Cordula also mentioned that, the gradual transposition or expansion of international armed conflict provisions to non-international armed conflict. So the ILC again adopts a general stance. It does not differentiate between international and non-international armed conflicts, apart from where it is totally necessary, and it does so in the commentaries of these draft principles. So these draft principles, they speak generally of armed conflicts covering both international and non-international armed conflicts. So this is what the ILC has done so far in relation to this topic. And now moving on to the next slide, I have chosen two specific draft principles, and this is also the last point Cordula mentioned about the biodiversity hotspots or the ecologically fragile or sensitive areas, and it is draft principle 17. You can see the text of the draft principle here. This is a draft principle that applies during armed conflict, and I have highlighted, you see the word agreement in red, because there is a specific explanation in the commentaries saying that an agreement can also be reached by a state and the non-state actor, by extension including, of course, also non-state armed groups. And this is something innovative, partially within the corpus of IHL. We mentioned that the concept of demilitarized zones is already familiar concept within IHL, but tailoring this specific area-defined protection to environmental, to the environment, the natural environment, is something totally innovative, and I'm really curious to see how states will react to this. The second example I have chosen, and turning now to the next slide, is draft principle 26, relief and assistance. It is a very pragmatic draft principle, and it is also linked to what Jonathan was saying, the responsibility of non-state armed groups and whether non-state armed groups would survive the war. Sometimes they don't, most of the times don't. So what happens when environmental damage has already occurred and we cannot find the source or who is responsible for this environmental damage? The ILC has adopted a very pragmatic stance. It calls states to cooperate and take the appropriate measures, focusing on remediation of environmental damage. This is an equally innovative provision which carries great potential in my view. Okay, and the last one is about the case study, Yemen, SAFER. So the SAFER, as you can see, is a terminal, a 40-year-old single-hulled supertanker moored 7 kilometers off the coast of Yemen. Houthis, the rebel movement, took control of the area in 2015, and since then, this area has never been inspected or maintained. It is estimated that it contains approximately 1.14 million barrels of crude oil, and of course, there is a huge impending danger should this terminal breaks down or erodes. There have been negotiations between the Houthis and the United Nations so that a UN inspection team could go there and estimate the danger and the risks. Actually, in February 2020, the issue of the SAFER found its way into a United Nations Security Council resolution. But again, since then, there has been no progress. It seems that this issue is used as a bargaining chip in the stalled peace negotiations, but the crisis is imminent. Even yesterday, the Undersecretary General for Humanitarian Affairs, Mark Lowcock, briefed the Security Council once again about this specific issue, calling them to take action, but still nothing concrete yet. And to conclude, just summarizing my findings and moving to the last slide. As we mentioned, there is a plethora of legal initiatives. The ICRC guidelines are soon coming out. The national pledges in the ICRC 33rd conference in December 2019. UNEA, the United Nations Environment Assembly, is seized of the matter, at least some aspects of the matter. I mentioned the Security Council just included a paragraph on the Yemen safer. So it seems that the international community is aware, or at least is increasingly being aware of the matter. I emphasized then the ILC draft principles, which in my view will be the point of reference for the years to come, precisely because of this comprehensive temporal approach they have espoused. As I mentioned, they are not yet finalized. We will have to wait 1 more year to see how states will react. And then just also to give my view on the question of the title of our webinar. Of course, this is a leitmotif, a common trope within international environmental law and IHL, improving implementation and enforcement of existing law. But we see, at least this is my perspective, that we also need to develop slightly the normative landscape. For example, when it comes to protected zones, the biodiversity hotspot. So it has to be a combined effort both strengthening implementation and also clarifying and developing the law. Thank you very much.
Thank you, Stavros. Thank you so much. So we have a few questions who have come in already. Where there is a clear orientation to a particular member of our panel, I will direct them that way. However, if any other members of the panel would like to chip in on that as well, please sort of raise your hand and wave, and then I'll come to you next. So our first question came from Harry Andrews, and he says, how might we promote demilitarized zones in biodiversity hotspots in the face of increasingly militarized conservation efforts? I will pass that one over to Cordula first because she spoke about it, but then if either of you would like to come in on that, please raise your hand and feel free. Thank you.
Yes, thanks a lot. And I think it's a very good question because there is, of course, increasing militarization, but that's about the militarization of something that should really be a police or law enforcement activity. Now, I think the crux for demilitarized zones is consent and agreement between the parties. So you will only manage to get respect for demilitarized zones in a way if you create the space, we call it often the humanitarian space, but let's call it the political space, so that the parties can know that they will not suffer a military disadvantage if they don't use a certain area for military purposes. And that has to be the case if both, that requires that both agree to this and can trust each other to also implement it. I think that's really the crux of such zones. How do you get there? I think, and that ties into something that Jonathan was also saying. In a way, I think you can try to make the argument that it can be in the interests of both parties. And very often it is particularly in the interest of non-state armed groups who are perhaps close to civilian populations that might depend on an environment that is not too damaged, and therefore might well agree, to protect a certain area as long as they know that it will not be to their military disadvantage. I don't know, perhaps Jonathan, you might want to add to that, but that's how I would try to argue for the interests of parties in having such zones.
Jonathan, feel free to add anything on that if you'd like.
Well, maybe I say, just following up from Cordula's, I think, yes, trust and confidence building is quite important. And we often talk about trust and confidence building when we come to conflict resolution, but we should also talk about it when it comes to agreements. We have built into international humanitarian law is the notion of further agreements between state and non-state parties to conflict. But it does take confidence. It takes an understanding of the non-state armed groups that they will feel that they are players who are at the table in these types of negotiations, and that the pen on paper actually means something. And then I think in the other way, states might have a unwillingness to trust these actors simply because, again, they're taking up arms against them. The integrity of the state might be in play. So I think we can work on building up that confidence between the parties, not just towards conflict resolution, but on these humanitarian issues. And in fact, that could also contribute to the conflict resolution confidence building at the end of the day.
Thank you so much, Jonathan. We've got a few questions coming in that are fairly broad, and I expect maybe more than one of you might like to come in on. So I'm going to send you two questions at the moment, if I may, and then perhaps we can go in order, in the order in which you spoke, and feel free to contribute how you like. So one question is, can the nationalities of the members of non-state armed groups bind them to international law? And this is from Paul Sullivan. And we also have the question, does IHL also cover areas that are claimed by both states but only controlled by one? And this is a question from Sai Krishna Piduru. Cordula, feel free to come in on whichever of those you like, and I'll turn to both of you next.
Did you say you want me to start?
If that's okay.
Yeah. The nationality is actually not so much what defines whether non-state armed groups are bound by international humanitarian law, but it's more whether they are a party to the conflict. So non-state armed groups can become a party to a conflict when you have a non-international armed conflict, which requires, broadly speaking, two things. One is you need a certain threshold of violence that is above the normal threshold of violence. And secondly, you require a certain level of organization of a group in order for that group to be considered a party, because it can respect also the rules of international humanitarian law. So that's what, so once a group is a party to a conflict under the notion of IHL, it is automatically then bound by international humanitarian law, regardless of its the nationality of the group or indeed that of its members. For human rights law, it's a bit more complicated because, as Jonathan has mentioned, and perhaps he wants to add something like this, there is a controversy, in fact, on whether non-state armed groups are bound by human rights law or not. And sometimes that's also tied to the amount of control that they exercise over a certain territory, in the sense that if they exercise state-like functions, then there is an argument to be made that that should also come with state-like responsibilities, such as human rights responsibilities. And then I think the question of the control, whether a territory is controlled but claimed by both. Yes, again, so the threshold of application for international humanitarian law is whether there's an armed conflict. That can be an international armed conflict, which is an armed conflict between two states or more. And that includes also what you call the situation of occupation, where one state controls a territory that might be clearly belonging to another state, but also a territory whose status might be controversial, but by virtue of the effective control that one state has over that territory, the law of occupation applies.
Thank you. Would anybody else like to come in on those two?
Well, as you said, in order, I'll just quickly probably avoid the human rights controversy, as we have 10 minutes left, and that's a subject that takes up some time, but only to say on that there's one thing to look at the negative obligations, and are non-state armed groups bound by negative obligations to not do something, but what about the positive obligations to do something? So I think it's a really interesting avenue to explore. We're just going to not do it right now. And just the only other thing I will say to make clear to those who may not be lawyers in the audience is that we also come in at it from two angles, because as Cordula said, when it comes to IHL, we talk about the party to the conflict being a state or a non-state armed group. But we can also look at it from the perspective of international criminal law, where the individuals themselves are subject to the international criminal law standards, and that depends on jurisdiction, and jurisdiction may depend on nationality, it may not depend on nationality. And I think I'll hand over to Stavros now, because we want to get him on board here.
Nothing to add on this one, actually. No, I wanted to add the international criminal law perspective, but yeah.
Excuse me. All right, well then we'll move on, because we have plenty of questions coming in. I think the next few will also be interesting to all of you, so please come in as you like. First of all, can you speak to environmental legal protection when it comes to armed conflict short of war? Is there any legal protection in this subset of conflict? And that's from Amy Schenk. And we have another question from Paul Walker, which is, does or could IHL or other international law help regulate non-armed conflict situations such as military training, military stockpile destruction, open burn or open detonation, or other serious non-war impacts on the environment? Apologies, please come in as you like, or perhaps Cordula, you can start us off again and we can go in the same order.
Okay, thanks. So as a matter of IHL, there's actually nothing like an armed conflict short of war. So something is an armed conflict or it's a peace situation, which doesn't mean to say that extremely violent situations can't be regulated. But the threshold basically is, do you have an armed conflict, which is either international, as I said, between two or more states, or non-international between a state and non-state armed groups, or amongst such groups. In that situation, international humanitarian law applies. Below that threshold, however, of course, the environment is protected by a plethora of international legal environmental standards. So there are many, many environmental law treaties. There are also many soft law standards on environmental law. So, you know, the Convention on the Law of the Sea, the Rio Declaration, etc., etc. So you really have a huge body of law, international law protecting the environment. And secondly, you have the body of international humanitarian human rights law, and many human rights have been interpreted to also encompass an environmental dimension, if you will. So, for instance, the right to health has often been interpreted by human rights bodies as also requiring states to pay attention to the environment. So, for instance, in the Convention on the Rights of the Child, or you have the, you know, the Covenant on Economic and Social Rights, which include these environmental aspects. And you also have certain specific human rights treaties, such as the Maputo Protocol in Africa about the rights of women, which has a specific rule about protecting also the rights of women to clean environment, simply put, and also to their participation in discussions around the environment. I'm paraphrasing, it's not exactly that what the convention says. So you have a lot of international law rules protecting the environment below the threshold of armed conflict. Most of those will also apply in armed conflict, but international humanitarian law only applies in armed conflict.
And oh, Jonathan.
Yeah, sure. I'll just maybe jump in here to say that non-state armed groups only exist under international law as parties to armed conflict. So in situations short of armed conflict, they don't necessarily have any type of legal personality or being addressed as legal entities. That said, we shouldn't be too dogmatic about what these standards are and how they actually bind different parties. What we need to do is come down to the level of impact on the ground. And there could be non-state armed groups who are not parties to conflict, who will have impact on the environmental situation. So we definitely need to make sure that we make efforts and reach out, make them aware of standards. Again, whether they're legally bound or not legally bound, we can have these discussions for eons and eons, but let's work towards improving the situation on the ground by engaging them on these standards.
I just wanted to add, yeah, below the threshold, mostly we will focus on human rights law, environmental law. An interesting subset again is post-armed conflict, where we might have some obligations, for example, arising out of weapons conventions to clear explosive remnants or the ordnance. The ILC also is doing some work in this respect, the post-armed conflict principles I mentioned, for example, calling for the inclusion of environmental considerations in peace agreements, or in SOFA agreements, status of forces agreements, peace operations abroad. So we could also focus on this element. Another thing, because it was mentioned in the questions about military training, etc. And recently I came across studies detailing the missions coming from the US and the UK military, and in many occasions they do not count towards the nationally determined goals, and it seems that this branch of the government, of the state, is the hugest emitter, the hugest polluter, and perhaps we could also do some work in this respect, try to integrate these emissions, counting these emissions towards the national, the overall national limit.
Thank you so much, everyone. We are running out of time, but I think we perhaps have time for one more question in the last 3 minutes, and everyone can perhaps give a quick answer because it's, again, quite a general one. How do you discern and implement the principle of proportionality during asymmetric conflicts? There are non-state armed groups who simply don't want to respect the law in order to erode the opponent's fighting will, and this is from Bernie Canton.
Okay, thanks. And sorry, I forgot to answer the question about the stockpile destruction. So there's quite a few treaties, of course, that speak about stockpile destruction. You have, for instance, a protocol to the Convention on Conventional Weapons about clearing of explosive remnants of war. You also have obligations on stockpile destructions in the Convention Against Landmines, in the Convention Against Cluster Munitions, and so forth. So there's quite a few conventions actually which have obligations on stockpile destruction. In terms of asymmetric warfare and the question of proportionality, I mean, the first thing maybe that I will say as ICRC is that we would not be able to say on the basis of our experience that there is more or less disregard for IHL by either states or non-state armed groups. This is really a question of case by case depending on the conflict. So the assumption that only non-state armed groups will disregard the principle of proportionality as it in itself is slightly problematic. Now, and what happens in fact with the rules on the conduct of hostility, so distinction, proportionality, and precaution, is they are disrespected or difficult to respect, actually, practically speaking, for the different parties in different ways. So if you're the weaker party, it will be difficult to distinguish yourself openly on a battlefield because you will be targeted very easily. If you are the stronger party, you might, disregard more easily the principle of proportionality in certain respects, also because you want to, because you have much stronger firepower, etc. So it is a very difficult question. In terms, though, of now coming to the principle of proportionality and the protection of the environment, I think the important thing is really even just to start with the awareness that the environment is civilian in its nature, in its character, and therefore has to be taken into account even in the proportionality calculus, which means that both non-state armed groups as well as states have to think about the effect, not only the direct effect, but the indirect effect on the environment that their attacks will have. And I do think that the more knowledge we have of that, the more data we have of that, the more foreseeable it will be to show also that impact on the environment and raise awareness for that impact.
Well, just very quickly as we're wrapping up, I think Cordula had my talking points on the asymmetry question, so I'm not going to add anything there. But I will say on the stockpile destruction, there are examples of non-state armed groups who have destroyed stockpiles of anti-personnel, landmines, or improvised devices based on their commitment taken under a deed of commitment under Geneva Call, which parallels the international obligation, because the Ottawa Convention on Anti-Personnel Landmines did not directly address non-state actors, but because of this vacuum, a deed of commitment was put forth by Geneva Call that was signed, and I don't know the number of signatories now, but it's certainly in the dozens, and several of those have in fact destroyed stockpiles under that commitment. So it's an example of engagement and how it can actually work.
Just a final word in relation to the principle of proportionality and perhaps to its sister or brother principle of precautions, applying precautions in attack. Also, the ICRC, in a study published in 2005, it espouses this approach that the precautionary principle under international environmental law could find its way in IHL through the application of the principle of precautions. Of course, it's a controversial legal issue, but still we can see how these two legal frameworks could interact, and through this principle of precautions, we could draw insights from the more protective field of international environmental law.
Thank you all so much. We will unfortunately have to leave it there because of time, but thank you so much to our absolutely excellent panel. I think our audience have learned a great deal today. We will be having more climate briefings in the next few months, so please do continue to look out for future events on our social media channels. And finally, yes, thank you all very much. Have a lovely day, and I hope we'll see you for another webinar soon. Thank you.